Hi, my name is Carl Pearson, and I have a lot of time on my hands. I'll just say incidentally that I've spent the past day or so trying to alert various people in the press of the fact that there's a possible cure for COVID-19 in the name of Draco, an invention back in 2011. That needs funding, and it seems to me that there's no way that this should not be funded, and it's a possibility, and probably a strong one, that this Draco could be a cure for the coronavirus. So I just wanted you to know that there is something here that needs to be done and could help us all. Meanwhile, I do have a lot of time on my hands, and this time I'm going to track down some missing mail. And what I've uncovered is another way to take away your property and rights and even your life. I'm 83 years old. I'm a high school dropout with no high school diploma. I received my BA magna cum laude in political science, then graduated from Harvard Law School, and have been a small business owner for 74 years, and I practice law full-time, representing owners threatened with foreclosure and loss of their homes, and now this added problem of the coronavirus, which makes it all the more important that they remain in their homes. I have, at this point, more time to investigate things than ever before, because I'm highly vulnerable to the coronavirus myself and have self-quarantined myself for 65 days now. Since 2017, the United States Postal Service, which is also known as USPS, has a free service called Informed Delivery Daily Digest, which shows you copies of the front of envelopes to be delivered to you in the next day or so, and identifies any packages that you ought to receive with the name of the mailer and a tracking number. The tracking number permits you, the recipient, to track the package as it is transported from one place to another, ending up at your address. I became a subscriber a few months ago, and as a result, I am going to explain how mailers are able to take away your property and rights and even life. The USPS problem is with the packages and also with the ordinary mail that it delivers. You probably are aware that in the United States there is a constitutional right to due process before someone can lawfully take your property or rights or life. This applies in both the federal and state court systems. Due process requires notice and an opportunity to be heard. Let's assume, for example, that you are a defendant in a home foreclosure action and that someone mailed to your attorney motion papers which to obtain a court order to auction off your property, in an envelope mailed in China with the mailer's Chinese name and address spelled out in English letters and numbers. You could safely tell the court that you did not receive notice and an opportunity to tell the judge your side of the case because you threw the envelope away as another piece of junk mail. The court would so uphold unless you admittedly received and opened the envelope and read the motion with enough time to respond to it and advise the judge accordingly, which of course you probably wouldn't have done. So here are two separate problems that I see, and now I'll talk about the first problem. The first problem is far more deadly than the second problem. This first problem involves the USPS, but not the Informed Delivery Daily Digest. Instead, it involves the way ordinary mail letters are used to disguise the enclosed notice and prevent the recipient's client from being heard in various legal matters, including foreclosure actions. So the homeowner has a much greater chance of losing his or her home and having no place to live for protection against the COVID-19 virus, among other adverse consequences, while the lenders and their loan servicers profit from evading the constitutional requirement of providing notice and an opportunity to be heard. So here is an example of how the denial takes place. And you put yourself in a position where if you are going to receive any notice that requires you to take action, you don't want it being mailed in China, and you don't want it being obscured that it's coming from X when really it's coming from Y. And think carefully now about what I'm saying, and this applies really mostly to law firms. That's more important because of the fact that you're so close to being thrown out of your home by a court. So here's the example. The lender or its servicer's law firm located in New York, prepares a legitimate motion for relief or a demand for discovery, which, if mailed by the law firm to the homeowner's attorney, would be appropriate notice and an opportunity to be heard under the court rules. However, instead of mailing the motion or discovery demand directly to the homeowner's attorney, the lender's law firm emails the letter to an outside company located 3,000 miles away from New York, that is in San Diego, California, for example, for printout and mailing to the homeowner's attorney in New York. The San Diego company prepares what I call a page 1 for use in identifying the sender and the homeowner's attorney in an unprinted window envelope. Instead of identifying the lender's law firm as the sender on that prepared page 1, which I call it, the San Diego company puts its own name and address on the page 1 and then inserts as page 2, a hidden page, the lender's law firm letter, wholly hidden by page 1, and then mails the letter to the homeowner's law firm that receives many letters each day, but very few motions or discovery demands. What my law office receives in the daily mail from many servicers and lenders with addresses from many different states is loss mitigation application forms, bank statements, escrow deficiency notices, demands for payment, all sorts of things in various sized white envelopes. The San Diego, California white envelope is mixed into these envelopes and gives no notice whatsoever that the letter is from a law firm and deserving of more immediate and special attention. And this is almost as if it's out of the playbook of lender servicer Wells Fargo, which we all know from publicity that it advised its employees and attorneys with that playbook how to obtain foreclosures when legal rules prohibited the foreclosure. The unprinted window envelope, which is for use with hundreds or even thousands of different law firms throughout the country, with 2 cutout windows, merely states for all mailings, and I'm quoting, P.O. Box 23159, San Diego, CA 92193-3159. And then it does state below that important information enclosed. The problem for me is that, 1, the law firm name is not disclosed. 2, there's a failure to disclose that the sender is a law firm. 3, San Diego, California is the place of business rather than the expected New York, or somewhere in New York as a law firm representing a plaintiff in a New York lawsuit. 4, the contents, that is the hidden page 2, are not information, but motion papers or discovery demands requiring a response, or my client could lose his or her home through default. 5. The page 1, which is partially revealed through the two windows, does not provide any additional information such as the law firm name or the documents enclosed or the case index number, so that even a second look at the envelope and page 1 in its entirety after the envelope is opened still does not indicate that a law firm sent the letter or that a lawsuit is involved. 6. Because page 1 was prepared separately from the letter, it could quite easily have had the name of the law firm inserted above the post office box number, but did not. 7. And page 1 could have said, quote, contains litigation discovery demands requiring a response, but did not. When the letter is received from the San Diego company, it does not appear to be from a law firm, and it is concluded by the defendant's lawyer or staff that there is no time-sensitive motion or discovery demand to be calendared and addressed with a court-required response. Even when the envelope is opened, a look at the prepared page 1 suggests nothing different. The fully revealed page 1 does not identify the lawsuit involved, or that the still hidden papers beneath page 1 are litigation documents from a lender's law firm. As a consequence, a high percentage of this type of letter results in a default by the homeowner's attorney and a default judgment, auction sale of the homeowner's home, followed by eviction of the homeowner and his or her family. Yes, the homeowner or his or her attorney could spend $10,000 to $50,000 in motions and appeals to try to correct the injustice, but this is seldom done because the homeowner has no money, and the courts generally are not oriented to results other than foreclosure and sale. Thus, the homeowner loses his or her property and his or her right to remain in the property for a much longer period, and probably any hope for a loan modification to keep the homeowner in the property permanently. Instead, because of denial of notice and an opportunity to be heard, the homeowner loses the home and the whole family is evicted with no money to move or rent another place to live, and is more apt to become infected with the coronavirus, has a lower credit score, has a huge monetary deficiency judgment, is less able to obtain a job, becomes dependent on welfare, with children less able to compete, often requiring more psychological and medical attention, with additional costs to the government through higher costs and lower tax revenue, and the lender's income and profits are unlawfully increasing all the time. That's the first problem, the more serious one. Now, the second one is a related problem, but far less serious, but has some of the same issues. Now, let's assume that the motion papers for your lawsuit in New York are in a package which the USPS tells you is from Walz Group in Temecula, California. That's WALZ Group in Temecula, California. And nothing from Walz Group is ever received by you. Because this is what happens. Instead of getting the Walz Group package, you get nothing. You do receive a package from someone else, but it doesn't tell you that that's the Walz Group package. Your attorney, meanwhile, is calendaring the receipt of the Walz Group package, and when it does not arrive, is spending his or her valuable time, perhaps 2 hours or $900 in value, calendaring arrival of the Walz Group package and then trying to locate the missing package. This cost is going to be passed on to you directly or otherwise. Because of this added cost, you may lose your attorney and wind up in default in the lawsuit, and lose your home, your credit score, be less able to get a job, and have greater vulnerability to COVID-19, all because Walz Group fails to tell you the USPS who is sending the package to you. It's not Walz Group, it's It's the law firm in New York. The package, when it arrives, has the name of the sender, but the USPS is advising you that the package is coming from someone else, that is the Walz group, so you think that you haven't received the package. So, by using a false name as the sender of a package, the actual sender has an opportunity to force an additional wasted $900 expense upon a homeowner and or his or her attorney, which statistically will result in perhaps $50,000 to $150,000 in improper benefits to the lender and servicer at no cost to them. Perhaps the availability of this video will enable some homeowners and their attorneys to avoid that wasted cost and needless consequences, and will also encourage others to send litigation mail in envelopes having the correct name and address of the sender. Well, I've said what I plan to say, and I'll say so long until my next video.